Hello, everyone. How's it going? This is Immigration Attorney Mamita. I'm coming to you live to talk to you about immigration and to see the questions that you may have on your mind today. Thank you so much for joining me. I hope everyone is having a lovely, lovely day. My name is Mamita Rahman. For those of you who don't know me, I am an immigration attorney. I have been practicing immigration law for the past 14 years, and it is my pleasure to do the work that I do because I believe that immigrants make America great already. So if you are joining me for the first time, go ahead and let me know what country you're from, what state you're living in. I always love to hear where my followers are from. And if you're a current client, please say hi. And if you have a question about immigration in general, about your case, something that is worrying you or concerning you, go ahead and pop it into the box below, and I will do my best to answer as many questions live in the time that I have today before I have to leave. But before I start answering your questions, I am going to answer two very important topics that I want you to know about. And the very first important topic that I want to talk about is, can you still file your I-751 petition to remove conditions on your conditional resident card if your spouse took away your card? And before I go any further into this, if you need to call our office, our phone number is 212-248-7907. And we work with clients all over the US. I'm just going to go ahead and try to pin this comment below. And happy Lunar New Year to all of you who are out there. Let's see if I can pin this number on Instagram. Okay, great. And hello from Los Angeles. I was just in LA last week. I hope you guys are doing okay from the earthquake that you guys just had and the floods and everything that was really crazy. Okay, let's get back to this question. If you have a 2-year conditional card, but your spouse took away your card, can you still renew your card to get your 10-year green card and then file for citizenship? Or is it all over because your spouse took away your card? And the answer to this is you still have every right and every power to file your I-751, whether your spouse takes away your green card, whether your spouse sends you back to your country, whether your spouse tells you that they will not apply for you, or whether you do file together and then your spouse actually cancels the case or they don't show up to the interview that gets scheduled for you by immigration. No matter what happens, if you have a 2-year conditional residency card, or if you had a 2-year conditional residency card that is long since expired, you can still file for your 10-year green card today. Because when your spouse does things like this, when your US citizen spouse takes away your card, or they don't help you file, or they cancel your case, or they actually trick you to going back to your home country and tell you that you have no right to come back to the US, you have no right to stay in the US without their approval, it is simply not true. And underneath these circumstances, you may actually be eligible to file for a waiver of your I-751 joint filing requirement. Now, the reason why there's this waiver and there are actually several other waivers available is because the US government is very well aware that when you are in a marriage with a US citizen, sometimes the balance of power can be off, especially where your spouse, your US citizen spouse, is the one who's kind of in charge of the paperwork. They're kind of in charge of even doing the petition themselves, right? So when you are reliant on them for securing your green card status or for removing the conditions on your 2-year residency card, believe it or not, you can actually take the power back into your own hands and file for that removal of conditions by yourself. Now, there are two particular waivers that you may not be aware about, but the very first one, which is not commonly understood, is the waiver for extreme cruelty and battery. In the simplest terms, if you're alive, if you look back upon your marriage, if you look back upon the history with your spouse, and you can see that they're the ones who are telling you what to do, you're the ones who are trying to make them happy, they're getting mad at you, or they turn on you, they use their family against you. You know, I have a lot of clients from South Asia. Let's say like you come to the United States and your mother-in-law or your father-in-law, they make you work in the house and take care of everything. They treat you like a domestic servant instead of a spouse. These are problems that can actually allow you to file for that I-751 application by yourself. And you do not need to have your husband or your wife's consent, approval, and they actually can be completely this case can be kept completely confidential from them too, because there are a number of protections. Now, number two, what if you have already gotten divorced from your spouse, right? Like, what if this happened many years ago? What if you had your I-75, your 2-year residency card approved many years ago, but then things didn't work out, you had to move out and you got divorced, and you are also underneath the impression that there's nothing you can do? That is also simply not true. No matter how much time has passed, there is no deadline to filing for a waiver. And even if you're divorced, you may be able to file right now. Now, if you are in the situation, time is always of the essence. But what I do want you to know is that even if your card is long since expired, or it's long been taken away, or even if you're returned back to your country, there may still be ways for you to come back to the US, and there may still be ways for you to secure your 10-year residency card, okay? So give us a call at 212-248-7907 if you are in this situation today. All right, let's go ahead and see what questions we have right now. I'm gonna go to my YouTube. And if you don't know, I am live streaming on 4 different platforms. I'm on TikTok, Instagram, and also on YouTube and Facebook. All right. So Abdul Rahman Rashwan is saying, why did USCIS start giving extensions for the conditional green cards instead of 10 years? Can I get an interview notice still? Abdul Rahman, well, they're giving you an extension of almost, I think, like 4 years at this point for your I-751 application, because they take so long. But in general, what I find is that these applications take more or less about 1 year to process. If your case ends up taking more than 1.5 years to 2 years to process for your I-751, to me, that's a sign that they're probably going to ask you for an interview. And interviews take a very, very long time. Let's see. Our AJ, hello. I'm your client. I filed my VAWA in October. I'm still waiting for prima facie, and I'm up for my renewal in DACA. I'd like to keep my DACA status until my I-360 is approved. Is that okay? AJ, absolutely. And actually, I have some good news. We just got a VAWA approved for one of our clients who has DACA just this last week. I'll make a video about that shortly. But yes, if you have DACA and you're also married to a citizen, but you're in a position where you need to file for VAWA, this is a great opportunity for you to get your green card, because when you have DACA, it's not really a status. It's very unclear. You may not be able to adjust your status without leaving the US because you don't have the legal entry into the United States. But if you have DACA, you can still 100% keep renewing your DACA status until your I-360 is approved. When your I-360 is approved, then you're going to have I-360 status, and then you're going to be eligible for your green card, all things being equal. So AJ, yes, please continue renewing your DACA application. If you need our help, obviously let us know. It's not something that's automatic. It actually requires you to submit an application to immigration if you have DACA. So again, if you have DACA status, you are still eligible to file for VAWA. You can still do a couple of other things to help you get an actual status in the United States without having to leave. But don't forget to renew your status, because that's not something that is granted automatically by the US government. Now, one thing that DACA applicants face a lot is the fact that they may not have a legal entry into the United States that would allow them to go ahead and adjust status even if they're married to a US citizen. So one thing that I do want to recommend to all of you is, if you are in the position to ask for an advanced parole with DACA, now is the time to do it, especially before, like election year is coming up. Guys, this is an election year, and the time to take action on your immigration case is now, sooner rather than later, because later, who knows what's going to happen. So definitely advanced parole is one of those things. It's still available to you right now as a DACA applicant, and I definitely recommend that you go for it. If you have any criminal issues, let's talk about it. Give us a call, okay? 212-248-7907. Okay, let's see what I have. I got married in 2017 with a U.S. citizen girl and divorced in 2018. I didn't file any case from Shubham Gaba. Shubham Gaba, if you got divorced in 2018, VAWA, your options are going to be a lot more limited. But if you went through, here's a situation where you may have been married to a citizen or to a green card holder. And even if you got divorced a long time ago, there may be situations where we could still do something for you, especially if you look back upon your relationship and you can see and say that your spouse treated you like a servant. They may have used violence against you or intimidation against you, or told you that you would get deported if you didn't do things around the house or please them in certain ways. Those could be an avenue towards something called a T visa. And T visa is a situation where either through your relationship or through somebody that you actually work for as an employee, your employer or that person uses fear, or they use force, or they play mind games with you, or tell you that you're going to get in trouble if you don't do certain work. So basically, when this happens, you're kind of working for for someone involuntarily. You're providing services not of your own free will. And when that happens, for immigrants who are undocumented, this is especially very important. This can be an avenue towards getting a green card in the future without having to leave the U.S. Even if you have a permanent bar, even if you don't have a legal entry, even if you have no American or U.S. citizen relatives at all, the T visa is actually a wonderful way to get status, and it's actually processing the quickest out of all the cases that we're doing right now. It's taking about 1.5 years. But the only way for you to find out what you're eligible for is to call us and do a case evaluation. We do have a case evaluation fee of $150, but if we cannot find a case for you, then we would actually refund you your money. And we are located in New York, and we actually work with clients all over the US. Now, this is a question that I do get a lot. I do see here somebody asking me where I'm located. We are located in New York City, but we work virtually with clients all over the country. As an immigration lawyer, I am allowed to practice immigration law basically anywhere. And I use that to my advantage to help persons all over the US who don't know what their legal rights are and who have been sitting in silence without being in fear, with shackles bound. My goal is to help unlock those shackles for you, okay? So call us at 212-248-7907. Okay, let's see what I have here on TikTok. Let's see. I got my employment card. Do I apply for Social Security card, or will I get one automatically from REMA? REMA, it depends on what you actually selected on your application. Mixcal Toya, my son is interested in joining the Army. Mixcal Toya, I'm assuming that maybe it's to help you get something or for them to speed up their process. Let's see. Ma'am, I lost my green card. I've been waiting for my green card since 2022. SK, definitely those applications can take some time. My parents are green card holders, and they applied for visa for my siblings in 2017. No update. So that's an interesting question from Sandy. Sandy, if your parents are green card holders, they can only apply for their kids if their kids are under 21, because as a green card holder, you're not allowed to apply for grown-up children or for children who are married. So definitely depends also on the visa bulletin and a couple of other factors as well. What happens if my SEVIS got terminated on the same day I got married to a U.S. citizen from Punam? Punam, it just means that you're out of student status if your SEVIS is terminated. Let's see. Can I expedite an I-130? How long does it take from Mamta? Mamta, you can expedite any application with immigration as long as you have some sort of emergency and you have to make a physical and written expedite request. All right. Now, another question that I have for you today is the fact that can you still file for VAWA if you only lived with your abusive spouse for 1 week and you never called the police and you just left even though you were going through lots of harmful situations? And the answer is yes. Let me go ahead and first of all walk you through the actual requirements for VAWA right now, because I want you to see that it's actually easier than what people say that it is. And a lot of people out there say that, oh, VAWA is impossible. If you don't have X, Y, and Z, if you don't have a police report, you can't file for VAWA. If you didn't live with your spouse for a long time, you can't do VAWA. And that is simply not true. Here are the basic 5 requirements to file for VAWA when you are filing for VAWA as a spouse of a U.S. citizen or of a green card holder. Number 1, you need to be properly married. And that proper marriage means that if you yourself were ever married to anyone in the past, you have to make sure that your marriages from the past were properly terminated. You need to have the proper divorce decree. You need to have done it according to the laws of the country where you got married and divorced. Your divorce needs to be valid, because if your divorce did not properly terminate your first marriage, even if you get married a second time to a U.S. citizen and you go through the worst sorts of abuse, your marriage may not be considered to be a legal marriage for immigration purposes. So number 1, you need to have proper termination of your previous marriages. Number 2, your current marriage to your U.S. citizen or to your green card holding spouse must be made in good faith. And all that this means is that the marriage that you entered into was actually for the purpose of joining your life together with your spouse. Now, a lot of people are fooled into believing that just because you ask for a green card, that means that somehow your marriage is not made in good faith or it's not bona fide. And that is also not true, because the thing is that if you are marrying to join your lives together, if you actually have an intention to be, spouses together, sharing a life together, that's really all that matters for VAWA. And as long as you're not only getting married just to get a green card and your marriage is not fake in that sense, then you are considered to have a bona fide marriage made in good faith. Number 3, if you are filing for VAWA as a spouse, you need to have shared residence with your spouse for any period of time. And that is literally what it means. It literally means that you and your husband or your wife must have lived together in the same place for at least one day, right? At least one day. When the law is written so broadly to say that you can file for VAWA after showing shared residence for any length of time, that's literally what it means. Any length of time. It could be one day, it could be 1 month, it could be 1 year. There is no minimum requirement, okay? Number 4, you must be a person of good moral character, which means that you can have some arrests, but it depends on when your arrests happened and what they were for. Now, generally, if your arrests are more than 3 years ago, it's usually not a problem. But if you have any sort of serious arrest, we must be able to analyze it to see if it will be a problem for your good moral character. And lastly, you must have suffered extreme cruelty or battery. Now, battery is literally any offensive touching. If your spouse has ever pushed you, shoved you, kicked you, pinched you, any force, anything with their hands that they've done that is unwanted by you, that is considered battery. And battery also includes sexual battery. So if your spouse has ever forced you to have sex or do anything in bed that you did not want to do, that alone is considered battery. And you don't need to prove it through like video evidence. You just have to be able to speak about it, and we just have to be able to write about it in your affidavit. So you do not need to have a police report to prove that you have suffered battery in your relationship. That is one thing that I want you to get out of your head, because I have spoken to one too many clients who have told me that other attorneys have said that they're not eligible for VAWA just because they never went to the police. And that is simply not true. Now, extreme cruelty is any sort of emotional abuse, manipulation, verbal abuse. If your spouse is ever cursing you out, if your spouse controls all of your money, if your spouse doesn't like when you wear certain things or let you go out or talk to people that you might talk to on a regular basis, these things are controlling, manipulative tactics, that your spouse may use to get you to do something or to prevent you from doing something. And that is considered part of usually a pattern of abuse that we use to show extreme cruelty. So that is literally all that we need to show VAWA. And VAWA is a great tool for you if you are in a situation where your spouse, your US citizen spouse, or your green card holding spouse is not applying for you, or they're giving you the runaround. If it's taking you a long time to get your case filed, your spouse doesn't want to share their taxes, or you find out all of a sudden that your spouse is actually still married to someone else, even though they're also married to you. These are situations under which you will probably have a better time filing for VAWA. Next, if you have an illegal entry and you were told by other lawyers that the only way for you to get a green card is if you leave the country and go to your embassy or your consulate for an interview, and you have to do a hardship waiver, but you're suffering in your marriage all the same, and it's taking a long time because these waiver cases take like 3-4 years, VAWA may be a good option for you. Now, VAWA may not be a great option if you have something called the permanent bar, because while we can fix the permanent bar through VAWA, it is a little bit more limited. So if someone has a permanent bar or multiple permanent bars, which can happen if you've crossed across the border many times, then we would like to look at something called a T visa. Now, another thing that we get a lot, some people think that, oh, my VAWA is not going to get approved because I'm still with my spouse. So what I have to say to you is this: you do not need to separate from your spouse. You do not need to get divorced. You could still be living in the same house, and you could still, for all outside appearances, you might look like you have a happy marriage. But really, it's about how what you're going through right now. It's about what you are suffering. It's about how your real life is, because nobody knows the truth but you. Okay. Anyway, call us at 212-248-7907. Daniela Chilean. Daniela, you're asking, I applied for VAWA, but I don't have money. How can I do it? Can I do it by myself in a USCIS website? I have all you said, but I'm in Chile right now. I was too scared in the US. Daniela, first of all, I'm sorry that you had to leave the country because of what you're going through. That sounds like it was really bad for you. And here's the thing: you don't need to have a lawyer to file for VAWA. Obviously, if you work with a lawyer, it's better because we have a lot more experience and we have a lot more knowledge of what's happening, but you can still file for VAWA by yourself. The VAWA application is filed with the I-360 application. And, like I've talked about a lot, the most important thing in your VAWA application is actually your affidavit. So as long as you take the time to write out what you went through, and show to the immigration officer how your relationship started, what you went through, the ways that your spouse hurt you or controlled you or used force against you. These are the things that immigration is going to look for. And just read the instructions, Daniela, and follow it and mail it in. You can't apply online. You have to file this. By mail. I think you can do it. But you can call us still, Daniela. Okay, 212-248-7907. Let's see. Hi, Floor. How are you? My girlfriend has a J1 visa and I'm trying to marry her. I want to know how much a lawyer is and how long the process is. Manny, you'll have to give us a call at 212-248-7907. It's not something that I can discuss. We can discuss without actually having more details about your case. Do we get a conditional green card for 2 years? Do we get an interview to extend for 10 years more from Imkawal Singh? Yes, sometimes you can get an interview. Sometimes you can get it approved without that. Monty Yug, I have a quick question about U visa. My wife is a beneficiary and she has a court case going on, but my son is born here and going to be 21 next year after the U visa. Monty, I believe that you're probably wanting to ask, can your son now file for your wife? And here's the thing: if you are the parent of a US citizen who's at least 21 and you're wondering, can my US citizen child file for me? This is going to boil down to basically one simple question. The one simple question that you have to ask yourself is, do I have a legal entry into the US? Because if you have a US citizen child, but you do not have a legal entry into the US, then your child is not going to be able to sponsor you easily. And the reason for this is that the government has basically imposed a lot of penalties for people who come in illegally. I guess they want to discourage, immigration. And if you have a U.S. citizen child and you want to be sponsored by them, you must have a entry with permission and inspection into the U.S. Literally, what this really means is you must have presented yourself to a border official who must have basically stamped your passport to allow you in. But here are a few situations where we can actually get around that. Number one, a lot of times, especially if you are driving through the border, like if you're in a car with lots of people and, how it is, there's a lot of traffic at the border checkpoints. And let's say like the immigration officer is just like the CBP officer, the customs officer, just ask for the passports of the people in the front and they don't really ask you any questions, but they see you in the car, right? You're not hiding, you're sitting in the back seat, you're in the car, and they say, all right, go through. However, even if you did not have legal documents to come in, as long as the officer lets you through, that is actually considered what is called a wave through entry. So that actually technically counts as a legal entry, even if you don't have your passport stamped. Now, the caveats to that is that one, we have to have proof. You have to show it. It's a little bit of a fight to get immigration to approve that, but it's possible. And I've done it in the past. So if you were actually waved through with the border and you're a mom or dad who has a 21-year-old child, we could possibly make an argument that you qualify for a wave through entry and get your green card that way. Number two, if your child joins the military, then we can ask for something called military PIP to get you in through basically erase that illegal entry. And number three, if you ever had a family member or an employer try to petition for you in the past, before April 30th, 2001, if you ever had an employer or family member file an I-130 or a labor certification application for you, then you may have protection underneath something called Section 245I, adjustment of status. And that also works to do the same thing. It basically converts that illegal entry into basically waives it and allows you to get your green card in the US. But if none of those happen, then if none of those are a possibility for you, then I like to see if, number one, you qualify for VAWA as a parent. And this sounds kind of scary possibly, but if you have any children who are 21, they're a US citizen, and they've given you a lot of struggle, they've given you a hard time, they've been rebellious, they've been disrespectful, they have hurt you with their words, maybe they have hurt you with their hands. Maybe they have broken things in the house. Maybe they have had problems with alcohol or drugs. These are not normal things. And if you have gone through that from your child, then we can help you file for VAWA. Now, parents in particular are very afraid to file for this because you are going to have a lot of conflicting feelings as a mom or dad. You love your child, but you deserve a green card and you don't want to get them in trouble. But here's the good news. These cases do not get your child in trouble. Your child will not have any record from this case. It is not something that is going to affect them in the future. And we have, I believe, we have had several of parent cases filed, no police reports involved, just sometimes a psychological evaluation. And sometimes it's just based upon verbal abuse suffered from your child. And this is a lovely way to help get a green card for parents who've been in the US for, pretty much like 20, 30 years without ever leaving to see their families, without ever having a work permit. This is actually a way that works. Now, if you have the permanent bar, one other thing that I like to look at is something called the T visa. And again, the T visa is such a wonderful tool that not enough attorneys are using. And we recently got a question from somebody saying, how come I never knew about the T visa before? And the answer is that people are just there's not enough lawyers who are educated about how to use a T visa. And here's the basic thing. If you have ever worked for somebody, whether it's in a store or a construction job or a nail salon or a farm or a factory, if you have whatever job you have ever had, if you have ever been afraid of your boss, I am not talking about you were afraid of losing your job, you were of getting fired. If you were actually afraid that your boss was going to harm you somehow, whether they don't, whether they're screaming in your face, whether they're not paying you properly, pardon me, 1 second, whether your employer has basically said that you might get in trouble with the IRS or the courts or immigration, and that fear drives you to work or to continue working for your employer. These are the circumstances, some of the circumstances through which we can get a T visa approved for you, okay? So anyway, call us at 212-248-7907. All right, let's see what other questions I have. Hi, my removal of conditions is taking long. It's been a year. Anything I can do? From user 1 year is actually very, very normal. Removal of conditions takes average 1.5 to 2 years. And that's why they give you a 4-year extension right now. But I would say that if your case is taking 2 years or more, then most likely they're planning to give you an interview. Is it possible for a second interview for removal of conditions? Sometimes. How does the parole in place work? My mother-in-law just got parole in place approved from Jaime. So Jaime, normally when you get parole in place approved, it's basically just kind of like allowing you to stay here, right? You still have to take other actions to file other applications like an I-130 to actually help you do your green card or your status. Flora, you're so welcome. It's my pleasure to be here. My husband's in the reserves and we've been married for 7 years and I have DACA. What would be my next steps? From Zendejas. PN Zendejas, if your spouse is in the reserves, then I would actually recommend that you try for something called military parole in place if you have DACA. But of course, if you have a legal entry as a child, then you may not need to do that. But if you don't have a legal entry, but your spouse is in the military, then the first step is to file for parole in place. Generally, this can take between 1 year to 2 years, depending on what state you're in and depending on what your local office is doing. And around the same time, your spouse can also file something called an I-130 for you. And once the parole in place gets approved, then that would be the right time to file your I-485 in order to do your green card process. Call us if you need some help, 212-248-7907. Is it safe to travel on advanced parole card? Does immigration give issues coming back in the States? From Keelan Favor. Keelan, yes. Immigration can give you problems if you are traveling with advanced parole. But generally speaking, for people who don't have any criminal convictions or charges or arrests, advanced parole is generally pretty safe. Now, I have not had a client have problems being able to return to the US with advanced parole, but also we are very conservative. And I literally tell every client that if you have ever been arrested, do not travel on advanced parole because it's going to trigger a lot of questions from Border Patrol. But sometimes I have seen that depending on the pre-clearance or the airport that you're in, if they don't know what advanced parole is, then you might have trouble boarding your plane or getting into the, getting across customs. But generally speaking, people that, at least our clients have not had problems returning to the US on advanced parole. Rodriguez, wish you were in South Carolina. Rodriguez, si usted está en South Carolina, trabajamos con todo la gente. No importa en cuál estado está ubicado. Trabajamos virtual con todos los gente en todos los estados, ¿ok? So Rodriguez puede llamarnos a 212-248-7907. Shin Picks, I have a friend who will need your help in regards to being lied to for sponsorship. Okay, this is actually a good topic. Are you working for someone who keeps promising you that they're going to sponsor you and petition for you, and they're going to pay you, they're going to sponsor you, they're going to give you, all these things, but they're not actually doing it? Believe it or not, that can also be an avenue towards getting the T visa approved. And when you get the T visa approved, it puts you on a pathway to a green card because you can apply for your green card by yourself after 3 years have passed, and then get your citizenship. So call us at 212-248-7907 if that's your situation. Okay, Bella's asking, I have withholding of removal 15 years ago, and I have my husband file my I-130. It's approved, but I went to court for my last individual hearing, and the judge send my case to DC. I'm from DC, from Bella. Okay, Bella, this is an interesting question. So if you have withholding of removal, or basically if you already have a deportation order, but you are now married to a US citizen, is it still possible for you to get your green card? And the answer is yes, it may still be possible. However, it's going to take a lot more work, and there are a lot more steps involved. Now, generally speaking, if you have withholding of removal, that means that you were already ordered removed by a judge, but they're withholding removal, right? Or if you have a deportation order, then it's already been entered in the court and your case is pretty much closed. So if you are now married to a citizen, you have to file an I-130, you have to wait for that to get approved, but technically you are still in the jurisdiction, in the house, basically. I like to talk about it as a house. When you're in court and you get an order of removal from a judge, you're still inside their house, right? The house is, you're still basically trapped in their house. So you have to ask the judge to let you out of that house so that you can file for your adjustment of status and get your green card, Bella. So normally what you have to do is you have to ask the judge to recalendar your case, to reopen your case. And sometimes it might mean that they have to change the venue of your case if you have moved. But once your case is back on the calendar, you can ask for the court to terminate it, to dismiss it, to, you can ask for prosecutorial discretion from DHS to dismiss all the charges against you. And then after that, you can file your I-485. Also, sometimes you can just tell the judge that you want to file for an I-485 adjustment of status in court, and you can file it with the court and then wait for a hearing date there too. So Bella, good luck to you. If you owe money on credit card, can that affect your VAWA case from G? G, no. So for VAWA and there is no immigration case that I know about that your personal debt would actually affect you in getting approved for your case. However, if you are applying for citizenship, you must make sure that you owe no unpaid taxes to the US government. And if you do owe taxes to the US government, you have to be on a payment plan with the IRS to show a good faith effort that you are paying off your taxes. Otherwise, they're not going to let you be a citizen, okay? All right. Yensi is asking, Jensi, is there a problem with the petitioning sponsor files only 2 of 3 years and he is required to file? He filed 2020, 2022, but not 21. My husband had a co-sponsor, but not sure if USCIS will deny. From Jensi or Yensi. Good question. If your spouse is actually doing a joint, an application for you where they're filing for you for your immigration status, one of the requirements for that is they need to have filed their taxes for the past 3 years and show proof of that when with the I-864 affidavit of support. Now, what happens though if your spouse is not really filing their taxes? Well, number one, sometimes you are not required to file taxes if you're not actually earning enough money to file taxes. But the threshold is pretty low. I think it's like if you earn $4,000 or less, you don't have to file taxes. And if that's the case, then you're basically waived from filing your tax return, but you can still file a statement with your application to show that you were not required to file it that year. But Yensi, if your spouse did earn money and he was supposed to file taxes that year, having a co-sponsor is not going to be enough, and he must get up to date on filing his returns. All right. How long does it take for a green card after work verification? From YDs? I don't know, man. It just takes as long as it's going to take in your case. It always depends on 2 things. It depends on, number one, what is the category of your case? And number 2, where you're located in the country. All things depend on that in terms of getting a green card. Can a person out of status get a T visa from Shin Peaks? Yes, absolutely. You can get a T visa even if you have a previous deportation order, even if you have an illegal entry, even if you have a permanent bar, you can still get a T visa underneath these circumstances. And it's going to put you on the pathway for a green card without ever having to leave the US. Are they still waiving interviews from Candy Hype? Candy Hype, yes, they are. Kuti Ranky. I filed for VAWA 1 year ago in a new relationship. Do I wait for the decision or possibly file for a new relationship? Kuti Ranky. All right, my friend, you know what I'm going to say? I'm going to tell you to wait for your VAWA because, okay, here is something that happens a lot with clients. You have been in a bad relationship and you come to us and you file for VAWA. And VAWA obviously takes a long time. And if you file for VAWA as a spouse, then one thing that you are not allowed to do is marry a new person, because as soon as you marry somebody new, you become ineligible for the application that you just filed. So you have to hold off on marrying somebody new. Now, what if you don't care? What if you don't care and you're like, you know what? Screw this. I want to move on with my life. I want to get married again. And I want my new spouse to file for me instead. Well, Cuddy, you know what? Guess what? The situation that you were in before was where your spouse was already making your life miserable and a hell, and you had to worry about not getting them too mad so that something doesn't happen to your case. And you'll be in that same position with this person too. And well, maybe you won't, right? But you never know. So why take that chance, Cuddy? Why take that chance to upend what you've already started, the path that you're already going down, just to put your life's control back into somebody else's hand? Keep it in your hands. You know, if you need, you know, it's okay for you to have a relationship. You can have babies, you know, you can move in with somebody else. It doesn't matter. Just don't get married. And my advice is to just stay the course and continue with the VAWA case. You will see a good end. But obviously this is your life. So if you feel like that you just don't want to deal with it any longer and you want to get married, and you want to have this new spouse file, then go for it. Go for it. Godspeed. And I truly hope that everything definitely works out. And if it doesn't, though, if you end up in a similar situation, then you could file for VAWA a second time based upon this spouse. Okay. I hope that helps. From Esme Nunez. I saw a good question, but I just saw Esme Nunez. My mom has been in Mexico for 13 years and I'm a US citizen. Can I bring her over? If so, how long? From Esme. Esme, good question. First of all, I'm sorry that your mom has been stuck in Mexico and you over here without being with her like that. But yes, if your mom or dad has been out of the US and you want to bring them back, it is usually possible. Now, Esme, the first thing that we want to look at is, why did your mom leave the US? Did she get deported? Did she have an arrest? How long was she here? Does she have the permanent bar? Because all of the answers to all of those questions are going to determine what we have to do for your mom's case. Now, sometimes all we have to do is just file an I-130 and wait for your mom to go to the interview, and that's it. But sometimes we have to file additional applications if your mom has the permanent bar, or she has an order of removal from the past. So, but yes, Esme, the bottom line is that it is possible. Call us at 212-248-7907. Can I apply for citizenship as my I-751 is pending from last 4 years and 9 months as I'm divorced? From Supriya, you can definitely do that. My advice is always to wait for your I-751 to get approved. Can my cousin adjust status if her mom became a US citizen when cousin was 8 and is now 42? From Claudia. Claudia, if your cousin is out of status, they're gonna need a waiver because they're out of status. So she can adjust, but probably not inside the US. Mendoza, I-485 approved for U visa and RFE medical exam was received. How long for residency? From Mendoza. So if If you got an RFE for your medical exam, that means that your I-485 is not yet approved, but it will get approved after you submit your medical exam, hopefully. Usually, I would say about 2 to 4 months is how much time it takes. User, VAWA and divorce. Okay, great question. Can you still file for VAWA if you have gotten divorced? And the answer is that it depends on when you got divorced. There is a very strict deadline in VAWA cases that you could still file for VAWA even if you got divorced, but your divorce cannot have been more than 2 years ago. If your divorce was more than 2 years ago, then you have missed that deadline for VAWA. There's one way around that, and that's if you never knew that you got divorced, if your spouse filed all the divorce paperwork without informing you properly, then you can actually go back to the state court and try to vacate that default judgment and basically get rid of that divorce date. But that's typically pretty difficult. But if more than 2 years have passed since the date of divorce, then I would love to look to see if a T visa or a U visa is possible for you. Okay, user, call us at 212-248-7907. How long does it take to get a work permit through VAWA? About 6 to 10 months. The processing time goes up and down. Can I apply for a work permit and green card at the same time? Because my wife stopped the process. We have kids and we are separated for 3 years now. Please help, from D Official 07. D Official 07, I am so sorry to hear that. Now, as long as you're not divorced, it sounds like you're still legally married and you have kids in common, we can help you file for a VAWA. Call us at 212-248-7907. Normally, when your wife, okay, here's the key word. If your spouse stops your green card process, that is a clear effort to control your life and to cause you harm, right? Most people, I have worked with enough clients, like even if there are problems going on, they still see the case through and, stick it through, to help so that the other partner is not put in harm's way. But where your spouse is actually withdrawing your case, stopping your case, refusing to go to the interview, refusing to give you documents, these are clearly manipulative tactics. And usually where this happens, there's a lot more things that have happened too. I'm pretty confident about that because we've done hundreds of these cases and it's the same pattern all over and over again. So D Official, call us please, 212-248-7907, because you may still be able to get your work permit, green card, travel document, all those things. Okay, my friend, 212-248-7907. I don't want to see you suffer. You have 3 kids, my friend. You have 3 kids. I can't even imagine. I have a feeling that you are probably not able to see your kids. Your wife might badmouth you to your kids. There's probably so much going on, and I don't want you to have to live that way. All right. Do you guys make service in other states for marriage-based cases from ILD Siku? Yes, we do. We work with clients all over the U.S. Wife with, oops, Nicole, here you go. Finally found you. All right, made you a moderator. A wife with asylum applicant with no green card yet is making me responsible for all of her debt and her family's debt because I'm the man and the janitor of the house. What can I do? From Eduardo Suyato. Eduardo. Okay, here's the thing. Marriage is meant to be equal. And yes, there are some people that might have more responsibility than others. But where it becomes unfair is if you are an undocumented immigrant, your spouse is controlling your paperwork process, and they say, you know what? Now that I'm doing this, you owe me everything, and you have to earn all the money. You have to pay all the debt. You have to buy me all these expensive things. Maybe they actually take on debt. They force you to take on debt. They run up their credit cards, and they say that it's your obligation and that you owe them. This is actually considered financial abuse. And where this is happening, there's more things than that. Also, if your spouse does these things to you and tells you things like, you know what, if you don't pay off these things, or if you don't earn this amount of money, then you're not a man. You are less than a man. That is also extreme cruelty. So Eduardo, call us 212-248-7907. We may be able to help you get your green card without ever leaving the US. We may be able to help you get your work permit and travel document. And you know what? Your spouse should not force you to pay off any debt. Your marriage is meant to be equal. It really is. Okay, Claudia, if we apply for citizenship, but the green card is near expiring, what should we do, or what can happen? Claudia, this is actually a very jurisdictional thing. Now, when you apply for a green card, when you apply for citizenship, you should have a valid, unexpired green card itself. And actually, when you're a green card holder, you are actually legally obligated to make sure that your green card is always valid. That means that if it's expiring, it is your duty as a green card holder to always make sure that you apply for it to be renewed, right? So what happens if your card is about to expire and you're about to file for citizenship? Well, I would actually say to please go ahead and continue renewing your green card, because there's no guarantee of how long your naturalization application will take. In some cases, it's taking like 3 months to do your citizenship. In other states, it's taking more than a year to do your citizenship. So you still need to have a valid proof of your green card status. You still need to be able to travel and to show it for whatever legal reasons that you need. But also because of the fact, Claudia, that depending on the location of your physical office where you are applying for your citizenship, some offices have a policy that if your green card is expiring in the next 180 days and you don't file for renewal, then you may have a problem with your naturalization application. So Claudia, definitely, I just recommend at all times, you never know how long things are going to take. If your green card's about to expire, go ahead and start that renewal process, okay? Omar is asking, I have an I-130 approved and I'm waiting for my I-485. My wife has threatened me so many times to cancel the process. What should I do? Wait for the I-485 to be approved or file for VAWA? Omar, thank you for asking this question. Now, here's the thing. We get this a lot, right? You may have already started the process with your spouse. You're waiting for your I-485, but your life is miserable. Your wife or your husband keeps threatening to cancel your case. So what should you do? Should you wait for that process or should you go forward? Now, really, Omar, you could do two things. You could, one, wait a little bit longer to see how long it takes. But for your I-485, depending on how much evidence you have, depending on any of the problems you have for your case, if immigration calls you for an interview, your wife is going to have that upper hand where they're going to say, you know what, now not only am I going to cancel your case, I'm not going to show up to the interview. Or worse yet, excuse me, guys. Worse yet, we have seen spouses go to interviews with immigration and actually tell the immigration officer that the marriage is a fake marriage, and that would put you in harm's way. So Omar, you could wait a little bit longer to see if you're going to get an interview or not. You could also just call it quits now for that process and just file for VAWA, because number one, it also depends on how much stress you are living with right now, Omar. And I find that the quickest way to get rid of that stress and to have some of that peace of mind back, to have some of that sanity back, is to file your VAWA case. So you could do two things, VAWA. You can do two things, Omar. I would say maybe you could give it just a little bit more time, but I would urge you to not let too much time pass. And something that happens a lot in relationships where your spouse is threatening to cancel your case, sometimes it's good, but then oftentimes it's a cycle. It just goes back around and around and around. And, like maybe they're happy one day and things are all good, but then they might get mad and threaten you the next breath. So how much longer are you willing to deal with that? That is the actual question, Omar. And when you need our help, call us, Omar, 212-248-7907. All right. What do you think about uploading unsolicited evidence for AOS from Leon? Leon, I don't do any electronic applications and I do everything strictly by mail. My policy is not to give anything unless they ask. If an undocumented immigrant marries with a U.S. citizen, can they make a paper for permanent residency? From Roshan Shrestha. Roshan, yes, it depends a lot on a lot of things. Number one, it depends on how you enter the U.S. Did you enter the U.S. with a legal entry or not? Because if you did not enter the U.S. legally, then even if you marry a U.S. citizen, it's going to make your case a lot harder. However, options may exist, so call us at 212-248-7907. Bonnie Bonds. If I have a C1D visa, can I be eligible for a green card? Bonnie Bonds. Bonnie Bonds. No. If you are doing a joint case with your spouse, if you enter with a crewman's visa, then you're ineligible to adjust your status. However, if you are doing VAWA or a T visa or a U visa, then we can get that waived, and it's not a problem. Namoli. I have filed my I-751, but I am separated now. What should I do? My application is about 20 months now. Namoli, I hope I'm pronouncing your name correct. It's a very good question. If you have filed your I-751 already with your spouse, but you're now separated and you're not living together with your spouse, what is your obligation? So my recommendation, well, here's the thing. When you file your I-751, these cases can take 1 year, 2 years, sometimes 3 years for immigration to process. And during this time, it is actually your obligation to keep immigration apprised of your situation. So if you get divorced or if you move, you have to update your information with immigration. Otherwise, if you don't update your information, then later, even if they approve your I-751, if they approve your I-751 because they think that you are still living with your spouse because you failed to update immigration, then you may later get accused of having committed a misrepresentation and fraud, and you may even get your green card revoked that way. So if you are now separated from your spouse, but you filed your I-751 20 months ago, my general advice would be to, number one, take immediate action to see if you are eligible for a waiver, and file that waiver with immigration ASAP before more time passes. Because if they happen to approve your I-751 underneath the impression that you're still living with your spouse and living in marital harmony, then that will actually cause you harm down the road, Namoli, okay? So you can call us at 212-248-7907. Can my military reservist husband sponsor my parents? From Zendejas. Zendejas, no, he can only sponsor you. And once you get your status, then you can apply for your husband. My asylum is pending for 10 years. My sister's a green card holder. Can she sponsor me? From Deeparetti. Deeparetti, she can sponsor you, but you're not going to be eligible to adjust your status because you're already out of status. Angelica, a person doesn't have a port of entry, and now that you're married to a citizen who has a medical condition, will that person need to go back to get a port of entry? So Angelica, I think you're talking about to get like basically your green card. And if you are now married to a citizen who has a medical condition, that doesn't change anything. We still have to look to see how to see what you're eligible for. Now, generally, most people who don't have a legal entry have to do a waiver unless they qualify for like something like VAWA or a T visa or a U visa. So, Angelica, I would actually implore you to call us at 212-248-7907. Now, something that you may be able to do if you have a U.S. citizen relative that has a severe health condition is to ask for something called medical deferred action. However, this is not a pathway to a green card, and it just allows you the ability to be here and get a work permit, okay? All right. From Junia, my friend is separated from her husband. She also fought for VAWA. She wants to give her marriage some time before divorce. Will it create any issues on VAWA? From Junia. Junia, And this is for everybody else who's filing for VAWA. If you want to file for VAWA and you also want to get divorced, will getting divorced affect your case? And the answer is no, it will not affect your case. You can stay married or you can get divorced. I encourage my clients to do what is best for them. Just keep in mind that, if you have not yet filed for VAWA or if you need to file for VAWA a second time, there is the 2-year deadline for divorce, okay? All right, everybody, that's all the time that I have for today. Thank you so much for joining me, and call us at 212-248-7907 if you would like to make an appointment to discuss your case. We are here to help serve, and we want to do whatever we can to help you get your status. So call us at 212-248-7907. Keep your head up high. Don't let things get you down, and just remember that you are worth it, okay? Have a wonderful night. Take care, everybody.